Hello.
How are you, Chad?
I'm doing well. How are you?
Can't complain. I know this is an interesting time for all of us.
I know.
How's my buddy Mike Baxter doing?
He is doing great.
That is my guy right there. That is my guy. He's head of State Bar Association.
Yep.
I'm telling you, we clicked and we got a lot done. And he's just a decent gentleman of the law, just the highest order. I have great admiration for him.
Mike is a great, Mike's a great lawyer, but he really is a great person, and has just done so much through the State Bar Association and with other organizations. Really remarkable.
Chad, good to see you.
Hey, how are you?
Good. Thanks for doing this.
Oh, my pleasure. This is a topic close to my heart, which is why it was so much fun to be able to have, decided to have the article published that with the University of Baltimore was really just made the whole experience of writing it just a little bit more special. So it's good fun.
Hey everyone, how's everyone doing?
Doing well.
Very good.
What?
Hello, everybody. Hello.
Good afternoon, everyone. And thank you for joining Law Forum and the Board of Advocates for Trial Advocacy, the Art of Storytelling. I am Parker Imani Payne, and I am the Symposium Editor for Law Forum. And I am actually going to hand it over to Dean White right now.
All right, well, thank you, Imani. Welcome, everybody. I am the Dean of the University of Baltimore School of Law. And if we were gathered in the John and Francis Angelos Law Center, I'd have a chance to welcome you to our school that way, but instead I'm pleased to welcome everybody to this virtual event. And I want to congratulate the Law Forum and the Board of Advocates for hosting this very interesting discussion with some fabulous panelists. We're persevering through this public health situation and finding ways to connect with each other and educate each other virtually. And this is a very good example of that. And I'm so impressed to see excellent attendance on a Friday night. Hopefully everybody will have a chance to enjoy some weekend after this, but let's stick with where we are. So congratulations, Imani Payne and the rest of the leadership of the Law Forum. Thanks very much to Professor Angela Valerio and Assistant Dean Claudia Diamond for advising the forum and the Board of Advocates as they put this program together. And thank you students and visitors for being part of this. I don't get to introduce our panelists, but I'll just tell you, I know them all to be fabulously well qualified to talk about the art of storytelling in relation to litigation. This is near and dear to their hearts, and so you're in for I think, very interesting and insightful discussion. Let me turn the program back to Imani, who I think is going to introduce the panel.
Thank you very much, Dean White. We very much appreciate you joining us tonight. And we do understand if you do need to get off early. Now,
we'll have to jump off, and I'm going to stay on for a while because I want to hear some of this interesting discussion.
And that's good to hear too. So now we're actually going to hear from our editor-in-chief of Law Forum and also the president of the Board of Advocates. I'm going to hand it over to Issa, and then we're going to hear from Kevin.
Hi, everyone. I'm Issa. I am the editor-in-chief of Law Forum. I want to go ahead and welcome all of you on behalf of Law Forum. We are very, very excited about the event tonight. We really do have some awesome panelists that, will discuss the importance of storytelling and trial advocacy. So it's going to be a great night. I want to go ahead and remind everyone that the Law Forum does have 2 publications every year. So if you're interested in a subscription, you can feel free to email me. I'm going to drop my email down in the chat so you'll have access to that. And I'm going to go ahead and now hand it over to Kevin from the Board of Advocates.
Hello, everyone. My name is Kevin Reynoso. I'm the president of the Board of Advocates. The Board of Advocates is in charge of moot court and trial advocacy. Trial team. And so if you're interested in either of those 2 programs, feel free to reach out. But thank you all for coming tonight. We really appreciate it, and we hope you enjoy it.
Thank you, Issa, and thank you, Kevin. That was wonderful to hear from you both. So now I'm going to give you guys a brief overview of this evening. First, we're going to actually hear from our panelists. We have 3 amazing dynamic panelists, Chad Joseph, Professor Anderson, and also Benjamin Beasley. And to hear a little bit about them, Kobe Lane, our staff editor, is actually going to do their introductions so you guys can get to know them more. After that session is over, we're going to hear directly from our panelists during a Q&A session moderated by Kevin, the president of the Board of Advocates. And then we're going to close out with questions from you all. So throughout the event, feel free to put your questions in the chat. And at the end, once Kevin asks his questions, he's going to ask you all's questions from the chat. Thank you all. Now I'm going to hand it over to Kobe.
Good evening, everyone. So our first speaker is Chad Joseph, who is a fellow of the American College of Trial Lawyers, which is one of the premier legal associations in North America and is composed of the best of the trial bar from the United States and Canada. Chad is an equity partner at Baxter Baker, which is a mid-sized multidisciplinary law firm representing local and national clients throughout the Mid-Atlantic region. As a trial lawyer, Chad handles a variety of complex civil litigation matters and largely focuses on defending healthcare providers in medical malpractice cases. He also has extensive experience representing parties in other types of complex civil litigation cases, including commercial, business, lead-based paint, and products liability matters. Chad has served as both lead and co-counsel in numerous civil jury trials that resulted in defense verdicts. Additionally, he has briefed and argued many appellate cases before both Maryland appellate courts. Before entering private practice, Chad had the privilege of clerking for the Honorable Robert F. Fisher on the Maryland Court of Special Appeals. Along with being a fellow of the American College, Chad is an elected member of the American Board of Trial Advocates and the International Association of Defense Counsel, which are both invitation-only, peer-reviewed organizations. Additionally, Chad's article, The Testament of My Wanderings in the Weary Land, A Trial Attorney and the Search for a Story, inspired this webinar and will be published in Law Forum's upcoming issue in late January 2021. So I'll now turn over to Chad Joseph.
Chad, you may be on mute. I'm not sure if you can hear me, Chad, but you're on mute.
There we go. My screen got screwed up. I'm sorry. I'm technologically impaired, so my fault. Okay. Can everyone hear me okay? Can you hear me? Okay, great. So thank you everyone for inviting me to speak. This is a topic that's near and dear to my heart. And I spent a lot of my career fine-tuning and working with incorporating storytelling into my approach to trial. And it's been you've probably learned in trial advocacy classes, you've heard about it, probably read articles that storytelling is a very hot topic in the trial world. Everyone's talking about you need to tell a story, you need to incorporate it. And part of what gave birth to the article was my frustration that no one ever really explained what a story was, and no one really seems to explain why it's important. And so that's what we've sought to try to do in the article, and what I will try to do in an overview here, at least in my talk, and hopefully get to some of the specifics in the question and answering. A story has very specific components. A lot of people equate a story with a simple narrative. They usually equate it. Lawyers are notorious for standing up in front of juries and saying, "Let me tell you my client's story." And then they go ahead and tell a whole lot of facts that they find are important. A lawyer standing up and saying, "Let me tell you about my client's story," does not make the words that come out of the lawyer's mouth a story. There are very specific components. The first real flushing out of the story and its components goes back to Aristotle. I won't bore you with too much of it, but Aristotle in the famous book Poetics broke down 5 general stages in drama for what a hero would do. And it was basically the introduction of the hero to some circumstances, having a challenge, overcoming the challenge, coming home, and then having this new win, what they gained in their experience. And poetics to this day, in those stages of Aristotle, are the mainstay of primarily theater production, in particularly drama. The world of storytelling essentially got an injection of steroids in the mid-1940s and 50s when a professor of literature, Joseph Campbell, who if any of you have taken a creative writing class, a class in mythology or such probably know, studied the different stories from across the world, the myths, the creation stories, the mythologies, and found that all of these stories from the middle of Australia all the way to Canada, all the way to the Far East and in between, all contain the same basic flow. They contain the same 17 stages or chapters that describe then the journey of the hero. That is, the central figure of these stories was the hero, and in all of these stories, in all of these cultures, follow basically the same path. Some may skip a stage, some may do it in a different order, but essentially these 17 stages are the cornerstone for all stories. And that essentially remains the gold standard today. generally. In 1985, a movie scriptwriter in California, Christopher Volger, who is a huge fan of Joseph Campbell, took Joseph Campbell's 17 stages and broke them down to 12. And Christopher Volger's 12 stages of the journey of the hero are the mainstay for movie writing today. And you cannot find a movie or book written today in fiction that doesn't incorporate these stages, these 12 stages or 17 stages or however you want to break them down. And Christopher Volger, and I won't go through each individual stage, but Christopher Volger summarized the hero's journey as follows. The hero's journey. The hero is introduced in their ordinary world where they receive a call to adventure. They are reluctant at first to cross the first threshold, where they eventually encounter tests, allies, and enemies. They reach the innermost cave where they endure the supreme ordeal. They seize the sword or treasure and are pursued as the road back to their world. They are resurrected and transformed by their experience. They return to their ordinary world with a treasure to benefit the world. That basic pattern exists in, name the movie now. You go through and watch any movie. The easy ones, Star Wars, Matrix, Hobbit, Black Panther, Thor, any of the Marvel series, any of these movies. Watch Prince's Purple Rain, it follows Volger's stages. Watch Spike Lee's Do the Right Thing, it follows the journey of the hero. They all do. And part of the reason for this, the part of why this stories have endured from the beginning of time, is because stories are used to help us make sense of the world. And they have since the beginning. Stories entertain, but they also educate. Stories have a moral lesson, and they are contained and enwrapped in the journey of the hero. It is why the story in this, as broken down in these stages, has endured while other forms of communication, other efforts, others have fallen. So here we are in talking about trial advocacy, storytelling. What does this have to do with putting on a trial? What does this have to do with writing an appellate brief? Now that goes to the essence of how we make decisions as people and jurors. And we'll put it in the context of a jury. The traditional thought is that jurors, after being instructed by the judge, go back into the jury room and make an objective analytical decision based solely on the evidence, ignoring their biases, prejudices, experiences, and all motion. And that is the expectation and has been in our legal system. It is probably what you were taught in your trial advocacy classes. It was probably what you taught in other classes. That presumption, based on the science of how we know people make decisions, is wrong. It is simply impossible for a human being to follow that instruction. The reason for that is because we, as humans, we have two halves of our brain. The left side is the logical and analytical side. The right side is the emotional and instinctive side. And we make decisions using both sides of our brain. So asking a juror to turn off half of their brain is basically impossible. And I would suggest that if you were interested in reading, there are two pieces at this point, and I'm not technologically savvy enough, I think, to put it into the chat, but I'll figure out a way to get the sites to people, is the two, if you want to be a trial lawyer, want to be a litigator, or just interested and you want to improve, there are two items I strongly suggest you read, in fact, would go so far as to say they're required. The first is you can go online and look up by Christopher Volger, the memo that started it all. It's 7 pages. It is his breakdown of the stages. It is anyone who wants to be a trial lawyer, it is an absolute must read. No question. The second piece is a piece that's called a white paper, which is a paper put out by the American College of Trial Lawyers. They have a jury committee. And it was a paper that looked at this decision-making model and how better to improve jury instructions. And you can look up white paper, American College of Trial Lawyers, decision-making jury, and you'll find it. And again, these are cited in the article that will be published. And I'll put it up. But the first part of the American College article is a wonderful breakdown of the science behind decision-making and why there are two, the interplay between the logical side and the emotional side. So now we have what a story is, and we have sort of the science behind the decision-making. And the question is, well, what does this all mean? What does this mean for the trial lawyer? How do I use it, and how does it relate to the trial? And the reason why the reason why storytelling is so important for a trial lawyer, or if you're writing a brief, or you're writing a motion and you're trying to convince a judge or anyone, is because a story with its structure, with its stages, puts the evidence in a form that resonates with both the logical and emotional parts of a juror's mind. The journey of the hero has implicit in it this sort of emotional back and forth. And you can organize your evidence in a way to tell the story so it resonates with both halves. Additionally, because the journey of the hero is so familiar, we all know it whether we actually appreciate it or not. How many of us have watched a movie and we say to ourselves, the hero's going to have a setback. The hero's going to overcome. The hero's going to meet an older ally or a teacher or a mentor figure. We all know it's coming. We don't know why we know it's coming. The reason is because the journey of the hero is ingrained in us through generation to generation to generation. But it is that familiarity that when you put the evidence in the form of this structure, makes it easier for the jury to understand because it's familiar to them. Think about it. A trial itself is remarkably jarring. Look, it's jarring for trial lawyers. Imagine the jurors who have not gone to law school, have not passed the bar, and have not been trained. You're putting 6 people in the box who couldn't figure out a way to get out of jury duty and ask them to decide, and you're putting up witnesses by which there is no rhyme or reason for an outsider to make sense of what goes on in a courtroom. It barely makes sense to us. So the unifying factor to the jury is if you actually then present the evidence not as a lawyer, but in a way that is familiar to all of us, it makes it easier for them to understand. Because ultimately, isn't that our job, to persuade the jury? And how do you persuade? You don't persuade by yelling. You don't persuade by volume of evidence or material. You persuade by figuring out a way to tell your position in the simplest way possible. And the journey of the hero allows you to do that. Now, the bad news for everybody is that it is not as simple as taking Volger's 12 stages and matching up your evidence and doing that. In fact, that is quite the contrary to what you should be doing. I will tell you that I was following this journey of the hero and putting my evidence and telling a story and doing it in this way before I actually was appreciative of what I was truly doing, because it was so ingrained. But there's a lot more to that. You have to apply strategies and tactics and themes and put them into this essential shell to prevail. There is not enough time today, barely enough time in a course to be able to go through all of that. We'll hit on some of that in the question of answers. But some of the most important things to remember, that when you're employing storytelling, it is about your client. Your client is the hero in this tale. Everything revolves around your client. Now, sometimes that can be pretty difficult to do. And sometimes you have to make adjustments because sometimes it just doesn't happen to work that way. Sometimes the facts, unlike fiction writers who can just make up facts, whatever they do, we're a little bit limited because we're limited by the facts and the evidence and what a judge decides we can put in. But everything revolves around your client and that story. So that when you get the complaint or you file the complaint, it starts looking for pieces of information to craft this story. You're looking for themes. You're looking to figure out, how do I reach this jury? And part of that is looking for elements and issues that resonate above and beyond just the simple mechanics of something, of the case. It's what I was taught very early on are called jury issues. There are issues in cases that are not related to the theme, not related to the elements of the case, aren't related even to the direct arguments. But because they involve emotional and logical components, they matter to the jury, and you must answer them, or you must capitalize on them as part of your story. For example, the single biggest medical malpractice case I ever lost as lead counsel involved a case of an orthopedic surgeon who did a knee replacement, and the patient developed an awful reaction 3 days post-op that required the removal of the man's leg. My surgeon, who was a very, very good surgeon, very, very well respected, did not see his patient post-operatively. He relied on his physician's assistant to do it. That is a completely appropriate thing to do. He was not criticized for it. But I was very worried about that because people want their doctors to be there. And it doesn't matter that it is irrelevant to the case of that jury. That didn't matter. It wasn't a criticism. That bugged the jury. I know it bugged the jury because the alternates told me it bugged them. And then the jury returned 23 minutes after they went back. That is not a good feeling. That had nothing to do with the elements of the case, but had everything to do with the emotion for the jury. Jury did their job. So I don't want to run over my time because I want to make sure we have time for questioning. So I will leave you with a short story that, in my mind, summarizes the polar ends of the sort of the trial lawyer world, at which up and coming trial lawyers, you have a choice in terms of what you want to be. There were two lawyers defending a physician in physicians in medical malpractice cases. One of the attorneys' name is John King, who was a real lawyer. John King was a legend. He's probably the founder of the medical malpractice bar in the state of Maryland. He was a fellow of the American College. He taught and trained the best of the Maryland trial lawyers. The other lawyer was a lawyer named Jack Wiley, who was a well-known traditional litigator. And Jack Wiley was going to win the case by selling his case to the jury, teaching the medicine, cross-examining the experts to show that they were hired guns, show that the plaintiff was exaggerating, and file all these motions in limine and objections. John King had no interest in that. John King was a fabulous storyteller. His focus was on his client and telling her story. So the second day of trial, plaintiff's counsel is going to call their first expert. And she stands up, calls the expert. John King and Jack Wiley sitting there. Jack Wiley has his depositions, his literature, his reports. He's going to cross-examine this expert. John King has a couple medical records. Mr. King goes into his old trial bag, pulls out a yellow legal pad, leans over to Jack Wiley and says, "Excuse me, son, may I borrow a pencil?" And Jack Wiley is just flustered because, John King is going to go first in cross-examining. He gives the pencil to John King and goes, "Mr. King, how are you going to cross-examine this expert? Where are your depositions and your reports and your materials? How are you going to sell your case to the jury?" And John King leans over to Jack Wiley and looks over his reading glasses, and much more traditional than what I have, and says, "Son, we don't care what the other side has to say. Remember, If our story is better than their story, we'll win the case. Now, that is slightly exaggerated for effect, but it is based on a true story. I have no doubt John King said that. And it illustrates the two sides. The lawyer on the other side who's going to just cross-examine and treat each witness as if the jury's paying attention on every blow, or John King who had picked out what was important to his case, his client, and was focused on telling that story. And therefore, there's a reason John King is a legend to many of us, to most. I've taken too much time. I'm going to pass the baton to the others, and I'm hoping to get a chance to answer some questions moving forward. But I thank you guys. Really, this was, this part was great. Other part's going to be even better. Thank you.
Thank you so much, Chad. That was wonderful. Some of the takeaways I took from it is your client is the hero in the story. We want to connect with the jury because they're familiar with storytelling. We see it in movies. The common theme in movies is the hero. Make your client the hero.
Yep.
I want to remind everyone that Chad's new article is coming out in Lawforum's upcoming edition, and it's going to be entitled The Testament of My Wanderings in the Weary Land, a trial attorney and the search for a story. So if you want to get a copy of it, please reach out to Issa, our editor-in-chief. She put her information in the chat so you can subscribe. Now I'm going to hand it over to Kobe, and he's going to introduce our next speaker, Professor Anderson.
Thank you, Imani. So Professor Jose Felipe Anderson, who is currently completing a biography entitled Genius for Justice, Charles Hamilton Houston and the Reform of American Law, graduated from the University of Maryland, Baltimore County in 1981 with a Bachelor of Arts degree in political science. During his time in college, he was active in student government, received several academic honors, and was editor-in-chief of the campus newspaper. A four-year varsity athlete, he was inducted into the university's Athletic Hall of Fame for his accomplishments in track and field. After graduating from the University of Maryland Law School in 1984, where he served as the editor-in-chief of the Maryland Law Forum, he passed the July 1984 bar examination and thereafter engaged in private practice for several years, handling various litigation matters. For nearly 10 years, he was a member of the Maryland Public Defender's Office. While with the public defender, he held positions as supervising attorney in the appellate division, special assistant public defender, and served as in-house counsel to the 500-lawyer, 800-employee agency. Throughout his career, he has been involved in the trial and appeal of many high-profile cases, among them several death penalty cases in Maryland's highest court, the United States Circuit Court of Appeals for the Fourth Circuit and the Supreme Court of the United States. After years of practicing law, he decided to teach law full-time at the University of Baltimore School of Law, where he was granted tenure in 1998. Earned promotion to the rank Professor School of Law in 2001. He was the founding director of the Stephen L. Snyder Center for Litigation Skills from 2000 to 2008. He received the University System of Maryland's Regent Award of Mentoring in 2006 and the Maryland Bar Foundation Award for Advancement of Unpopular Causes in 2001. He served as the chair of the Maryland State Bar Association Section Council on criminal law and practice. He has also co-authored a casebook on criminal law, has published numerous scholarly articles, and was elected to the prestigious American Law Institute in 2002. He has also taught since 2003 at the University of Pennsylvania as an adjunct professor of legal studies and business ethics at the Wharton School, and has served as a faculty member of the National Judicial College. Without further ado, Professor Jose Anderson.
Well, greetings, everyone. I must say I am very honored to be here, and I'm very pleased that, there are 50 people here on a Friday night to hear about trying to be a trial lawyer. And that excites me so much because we need you. Okay, we need you to be available for this, because to me, this is the essence of what lawyers do. And I love my work there. The panel is so outstanding. And, my colleagues tonight, I like to call it the classic UB, right? They earn it every day and want to, they want to go out there every day and earn their stripes as being a first-rate lawyer, because that's what they enjoy. And that's the only way you're going to keep it there. The topic tonight, storytelling. Wow. And so I think there are a few of my students here in the audience tonight, and maybe some of you will be my students in the future, but my students are fond of hearing me say, and sometimes many times during the semester, as a lawyer, all you are is the teller of other people's stories. That's what you are. That is the job. The job is to tell someone else's story. That's where the money comes from. That's where the prestige comes from. And the craft of doing that and understanding the importance and value of that is really what makes our profession unique and what makes it worthwhile to me. It's funny. Some of you may have come to law school thinking, hey, I want to be a lawyer because I want to do the courtroom thing. Some of you may have come to law school and thought you had no interest in that. And then one day you're going to find yourself being in that position. It's inevitable that the idea of sharing stories in the midst of advocacy, in rules, and in a framework has some similarities to other things that we like. Chad talked brilliantly about lawyers on telling stories throughout the ages, people telling stories throughout the ages, the hero idea, the idea that people can relate to. I will just tell you that there's nothing like sitting in a courtroom watching great lawyers put a case on, and the greatest of them engage in high-level storytelling, purposeful, well-prepared storytelling, and they use their judgment, to figure out, how do I get this story to the audience, whoever that audience is. The 12 people in the jury box in a criminal case, the 6 people in Maryland, or the 12 people in the federal jury box in a federal litigation. Don't believe what you're hearing. The prestigious American College of Trial Lawyers, which Chad is a member of, did an outstanding report about 2004 talking about the vanishing jury trial, which just discussed the whole idea of what's happening with the jury trials. It seems to be disappearing from our world. It may be that it's disappearing, but to me, it's more essential than it ever has been, because it's how ordinary people participate in our democracy. It's the foundation of our democracy. It's the proof that democracy actually works, because here are these people who assemble to do one job and disappear back in the community. They're almost like a branch of government that really keeps the whole thing together. And so if you get the privilege of participating in a case that might ultimately be submitted to the jury, it doesn't really matter that all those cases don't make it all the way to the jury process. And as I like to tell my students in litigation process, some of my best work is in Iron Mountain somewhere in a file that's closed up. The case I wish I had tried, but the client got the result that the client wanted. But the importance of that is to understand that when game time comes, it's going to be in front of people, strangers, that lawyers are going to have to convince, is part of the process of becoming great at storytelling. And so I just share with you guys, whenever you get your opportunity to tell someone else's story, is part of the greatness of the profession. That might be to an insurance adjuster on the phone. It might be to justices on the Supreme Court of the United States. And I got to tell you, you have no idea if you're going to be the one that's going to have that opportunity. You can't sit here today and say, no, it won't happen for me, because you cannot. Just be prepared for when it happens. Just a couple of points by way of highlights I think I wanted you all to hear. First of all, let me just make something absolutely clear. Storytelling is actually a great skill that's part of great lawyering, but it is not the object. It is a tool of great lawyering. What do I mean by that? Some of you youngsters, after we get off tonight, will probably watch the championship basketball game for the NBA. I know I'll be watching it. Way back when I was younger, much younger, and I think Chad might be able to relate a little bit. Ben, I'm not sure age-wise, but there used to be a great basketball coach at UCLA by the name of John Wooden. John Wooden. This guy won 10 championships in 12 years. NCAA, what we now call March Madness Final Four. 10. What an incredible record. He was an incredible teacher. He also was an incredible storyteller. But you know the first lesson he wanted his players to know and the people that he influenced? He said, you know, so many people are trying to learn the tricks of the trade that they never learned the trade. And boy, that's so true of lawyers. You can be the best storyteller in the world, but if you haven't prepared your case, prepared your witnesses, anticipated problems, laid the foundation for how the other side is going to tell their story, you don't have the temperament to figure out how your story fits into the story of the other side so that you can tell a better story, you're going to miss opportunities to be successful where you could have been successful. And so the first thing I'm going to say is preparation, preparation, preparation. And I know my panelists believe it. You know, they are working for firms that are well respected, and their clients, believe it or not, this is going to sound crazy. Their clients, though they don't like paying money, they're happy to pay for the good lawyering. It's part of their package of how their clients move about with their lives. And it's how these gentlemen protect their stories, right? The story to continue their business, the story to continue their practice, the story to get rights resolved. And so understand that we're part of a great story that is the story of lawyering. And so I want you all to get excited about that if you decide to pursue this. So many of you here are going to be on trial teams. I think it's a great exercise in law school to have an opportunity to do that, to go in front of these competitions with, you know, these judges and these lawyers who don't know you, who are going to score you on how you do and give you feedback in your oral presentations. And you're going to be nervous. You're going to have butterflies in your stomach. That's okay. If you're not nervous, that means you don't care. I know we're all nervous when we go to court. I have been in court a lot, and I'm telling you, I am just as nervous today as I was the first time I argued a case. And that's okay. But do the work so that you can manage the nervousness, right? That's part of it. And so I will say that with storytelling is that if you care about the story, you should be a little nervous about the story, right? And so you can be confident, well prepared, and nervous is okay. Let me talk about great storytellers that I have seen, just for purposes not of, you know, raising them up, because some of them you've never heard of, but they all brought some characteristic that I think I want you to know about. Okay. Some of the greatest trial lawyers I have seen are so different from each other. Oh my goodness. There's no prototypical courtroom storyteller. There are effective storytellers because they stay in their own skin. They stay in their own style. They go everywhere from miraculously flamboyant, like one of my mentors and tormentors, the quintessential Billy Murphy, who I've done cases with, and I've watched him do things. And I'm telling you, it's like surfing. It's like, how does he not fall off the board? But at the end of the day, he gets results. I don't know. It might be an intangible. I'm going to tell you a little secret. The man prepares. Before trial, he really doesn't sleep. He prepares. Preparation is important, but he's more to the flamboyant style. Another great trial lawyer, some of you may have heard of him in the context or read opinions in the context of his judge work. One of the senior judges on the United States District Court for the District of Maryland Fred Motts. He almost looked like he could work in like a big giant library because he seemed so quiet and he seems so measured. But don't make any mistake, he'll strike like a viper. He'll line up evidence and he'll line up the story and he'll go back and clean the story up in front of the jury, and the jury will say, how can I disagree with this man? This man laid it out for us. I don't even want to hear what the other side has to say, because he was so organized and so systematic how he went about telling the story. It fits with his style. He does it in his skin. He knows his strengths and weaknesses, and he wouldn't worry about the flamboyance of the other storyteller, because he knows his strength is the measured building block approach, which he's comfortable with. And in the federal courts where you have multi-day trials, being able to pace yourself for storytelling is really important, because you can't be flamboyant every moment of every trial all the time. And it's not even appropriate all the time, depending on the kind of witness. These are just two examples. A lawyer I worked with early in my career, I had the great privilege of working for George Russell, the elder, and Kenneth Thompson, two of the greatest trial lawyers there ever were. And I remember the advice they gave me. They said, for the first years of my career, be quiet and listen. Then maybe you'll learn something. They were right. Listen to a good trial lawyer put a case together. They had a likability factor because they understood how to boil the story down to the crucial facts that mattered. That was their great skill. That was their great skill. Some of you might have heard years ago about a mayor in Washington, D.C. by the name of Marion Barry. He was represented by a lawyer named Ken Mundy, who's passed away some years, one of the great trial lawyers in the history of this country. Ken Mundy had a certain gravitas, how he moved about the courtroom. It's almost like he floated across the courtroom to question witnesses, to talk to people. He had a certain elegance about him that he used that to create the atmosphere for telling a story in front of the jury. Another great trial lawyer telling a story. In fact, I don't think she gets to try so many cases anymore because people want to settle. They're scared of her. UB alum Kathleen Cahill. She's done some things around the school. And if you ever get an opportunity to either be in one of her trial advocacy classes, the reason I point these people out is that they're so different from each other, but the fundamentals are the same. I got to deliver the goods to the person I need to persuade. So one of the lessons they would all tell you about storytelling is that you're always practicing, for game day if you're going to get in front of the jury. But there's a whole lot of people to tell the story to before you get there. First, start with your client, right? The client gives you information, you digest what the case is about, and you learn how to tell the story to your own client about how you're going to go about navigating the risk and reward of going to trial if you all have to have a trial. Then there's opposing counsel. You're telling the story every time you file a motion, every time you have a conversation on the phone, even sometimes when you're discussing procedural issues like postponement and the scheduling order, right? And when we're going to get our experts ready, and when we're going to talk about which pretrial motions we're going to file. That's storytelling. Every judge you encounter, some of them might be judges in mediation, arbitration. They might not even be the judge that's going to try the case, or they might be the judge that's going to try the case. That judge from minute number one is forming an opinion about the story that's going to be told. And my UB students who have done so many internships with judges, I'm telling the truth, because you have been in those chambers when the judges have said, lawyer so-and-so, I don't know, they're pretty successful because they tell a good story, and this lawyer, I'm not sure I trust their story. So trust is really important. People have to trust that you're going to tell a story that has truth. Ethics of the highest level is part of storytelling. But that also means making judgments about when to blunt the blow of bad information, when to confront it, and when to try to soften the blow of it. So let me just wrap up my time and my introductory statements by saying, first, strive to be good at your preparation at lawyering, and your story will get better, even if you're still just as nervous. I mean, nerves, that's just a function, again, of caring about the case. I know that I have an issue. My students will my hands shake. I can't hold paper in my hand. See, I have to hold it with two hands. You'll never see me hold one piece of paper in my hand ever, because I know I can't fix that. I remember Chad's great mentor, Judge Fisher, who was one of my favorite judges to argue in front of in the Court of Special Appeals, because he let the lawyers do their job, But I'd be nervous in front of him because I knew he was paying attention to everything. He read everything. He knew everything that was in the record. But you have to understand that being nervous meant dealing with it, right? You deal with what you have to do. So get to preparing a story and don't worry about if the story's not going to be believed. I would say that, experiences from the lawyers you meet are very important. Ben clerk for Mickey Norman in Baltimore County. Mickey Norman and I fought each other like dogs for over a decade on a case, like dogs. Boy, it was tough. But you know what? Out of that came the respect of understanding that, look, be good enough to lose a hard case every once in a while. Make the story important enough and make your preparation for it important enough that after it's all over, people are going to leave the courtroom, and the judge is going to say, hard fought, and you did, you came, you did your thing, you took your cuts at the plate. And that's also a great part of the privilege of lawyering, to tell stories in that way. So I'm going to be done here with my sort of idea about storytelling, and listen to the rest, listen to Ben, and listen to some of your questions. But get excited about being part of this, gang, because you wave the UB banner high. Look, you all are out there whooping people. That's the bottom line. And the more you whoop them, the more it's good for us. And then call Dean Weiss and, give him a donation, right? So that we can continue this stuff strong. He didn't tell me to do that, by the way, but I get it. Any event, thank you all.
Thank you so much, Professor Anderson. I can hear your passion and your zeal for trial advocacy. One of the key takeaways I got from yours was the quote, "As a lawyer, all you are doing is telling someone else's story." And that is key. And that's what we're talking about tonight. One side can tell this story, the other side can tell this story, but what is the jury going to believe? We thank you. And I also want to bring to everyone's attention again that Professor Anderson is having his book released in 2021 and is entitled Genius for Justice, Charles Hamilton Houston and the Reform of American Law. So what I'm going to do is I'm going to put the link for the forthcoming book. And now we're going to hear from Ben Beasley, and I'm going to give it to Kobe so he can introduce him.
Our last speaker, Benjamin A. Beasley, is a 2014 graduate of the University of Baltimore School of Law. While attending law school, Mr. Beasley served as managing editor of the University of Baltimore Law Forum and as co-captain and competing member of the National Trial Competition Team and the Phi Alpha Delta mock trial team. Mr. Beasley also spent time interning with the Honorable L. Robert Cooper of the District Court of Maryland for Baltimore City and the Honorable Marcus Z. Schar of the Circuit Court for Baltimore City. Immediately after graduating law school, Mr. Beasley clerked for the Honorable Mickey J. Norman in the Circuit Court for Baltimore County. Mr. Beasley is an active litigator. His primary area of practice involves prosecuting and defending a variety of civil actions, including auto tort, premises liability, products liability, medical malpractice, and breach of contract matters. I'll now turn it over to Benjamin A. Beasley.
Well, thank you very much for that introduction. It's great to be with everyone here tonight, and thank you for the opportunity. Also, as I was introduced, being a law forum alum, it's nice to see the law forum doing so many great things early in the semester, and particularly against the backdrop of the pandemic and using technology to really promote the school and everything. So I really appreciate Imani and everyone else behind the scenes, Kevin and everyone associated with Law Forum for putting this together. One thing I wanted to really touch upon with everyone, and this comes as someone not too far removed from law school, in practice, and also coming back to school as an adjunct professor for the trial team, is from my perspective, from the trials I've seen as a intern with the judges I've interned with, as a law clerk, and then in practice and in my own practice. I often find that some of the best storytelling comes when you focus on some of the details. Now, we all know the saying, "The devil's in the details," and I really think that's where great storytelling can come out. One other thing about me too that was not contained in my background, and that's perfectly fine, is that before law school, I was a teacher in secondary school in Virginia, and when you're a teacher teaching a group of fifth graders. Concepts that are really not that difficult. You learn pretty quickly that you really have to break things down, focus on details, talk about things and explain things in a way that really just kind of cuts to the core of things you wouldn't even think that you'd have to like explain to just anybody else. And so when I think of storytelling, you have to put yourself in the perspective of a juror who's sitting on a jury panel. They know nothing about the case. They know who you are based on the voir dire that's happened. They might know a little bit about what the case is about. They might know who the parties are because the judge has introduced them and given an indication of what the issues are. But that's about it. So they really come in with these, and your jurors are these blank slates with no information whatsoever. And if you cut out crucial details of your case, not only things that would really help make your case, if you're on the plaintiff side or the state side, and meeting your burden, or even casting doubt on issues. Details often come into play when you're telling a story, not only to paint the picture for what actually happened or what you're trying to describe, but also to tug on the heartstrings, especially if there's an emotional component to your case. And so what I plan to do is kind of give you an example of kind of where you find yourself short shrift if you don't go into some of those details. And I'm going to try to be brave here and see if I can share screen. I think I have that capability. Imani, let me know if I'm missing anything. Did I do it right? All right. I'm told this is up on the screen. Everyone can see it. So if you're one of my trial team students, what's in front of you might sound a little bit familiar, but most of you are not. So I'm going to kind of break this down for you. Basically, what I have here is a very short shrift, an opening based on a fact pattern my team is working with, and would be an opening for the state that you would really never ever give. But I think when you compare it versus another version I'm going to show in a second, it really shows how some of the details can really make or break the story you're trying to tell. Now, I know that many of you are listening, and for those of you who are reading this, you have it in front of you. I'm going to read it out loud, so if you're listening, you kind of know what we're talking about, and then I'll go into some details about this. So here's version number one of this very, very poor, what I would say poor opening statement delivered by the state in a case that my team is working on. On April 30th, 2018, the defendant, with the help of Tim Parker, met with one of Tim's friends at the Quick Stop where they smoked marijuana. Later, they went to the park, had a few drinks, did more drugs, and then drove home. While on their way home, the defendant lost control of the vehicle, crashed, killing 2 victims. The state intends to prove that the defendant is guilty of 2 counts of negligent homicide while under the influence. Now, reading this, you have a general idea of what's going on. You know that there is a defendant, 1. There are 2 victims, presumably who have died. And there's a drinking, driving, and use of alcohol or controlled dangerous substances. But that's about it. And so really, you don't even know the name of the defendant at this point either. There's mention of drinking. You don't know what was had, when it was had, those kinds of things. So I'm going to show you a second version that adds a few more details. And part of the reason why I'm doing this too is that in teaching trial team and in being involved with the trial team that I coach and having done so for several years, I've been affiliated with the team now on and off for 9 years now. I think one of the things that people, students who are just trying to enter their practice, what they struggle with if storytelling is not a natural thing is, you're so engrossed in the weeds of the case. You know it, okay? You know who Tim Parker is. If you read the statement right here, I don't think you can tell me other than that he was with this defendant. You don't know what other drugs were being done that night. There's not a whole lot you really know about this case. You don't know anything about the victims in this case either. So really, other than the fact that something bad happened, there was a crash, there were deaths, some drinking and drugs were involved, you really know nothing about that. And I mention that just because a lot of times when I see students of mine give opening statements, closing arguments, but particularly opening statements where it's the first chance that you have as an attorney to really speak to your audience, to tell them what the case is about from your client's perspective and to really advocate for them. Some of these details are absolutely crucial. And when we're buried in the weeds of our cases, when we know them backwards and forwards, like the back of our hand, we have a tendency, if we're not too careful, and if we haven't prepared as well, to go over and to gloss over details that are really, really important for the jurors to know and understand our case. So here's version 2, which should hopefully give you a few more details about this case. In the early morning hours of April 30th, 2018, the defendant, Bree Candy Trevino, decided she wanted to go out and have a little fun with her boyfriend, Tim Parker. That night, Tim had custody of his 3-year-old daughter, Pippa. Tim had no one else to watch Pippa. He couldn't leave her alone, and he couldn't find a babysitter. But that didn't stop the defendant. Instead, the 21-year-old defendant dragged Tim and Pippa along on her night of drinking and doping. The defendant started her night off where she met up with one of Tim's friends, Jake. Jake was working as a bouncer at a club in town. The defendant arranged to meet Jake during one of his breaks around 2:30 in the morning. They met at the back of a nearby quick stop by the dumpsters where they smoked marijuana. The party continued. The defendant then drove Tim and 3-year-old Pippa to a nearby state park. The defendant met up with friends, drank several twisted teas, and took a hit or two of MDA, known by its street name as Molly or Ecstasy. The party at the park was so rowdy that the defendant was kicked out. With nowhere else to go, she drove Tim and Pippa home. While traveling 70 miles per hour on Interstate 10, with alcohol, marijuana, and ecstasy coursing through her veins, the defendant lost control of the vehicle. She initially drifted into the median for 237 feet. The defendant then drove back onto the highway, but overcorrected, causing the vehicle to roll as many as 4 times and going airborne as high as 29 feet. During the wreck, Tim and Pippa were ejected from the vehicle. Tim sustained blunt trauma to the head, killing him instantly. Pippa's small body sustained multiple fractures to her ribs, left arm, and both of her legs. The amount of time it took for Pippa to succumb to her injuries is unknown. The state intends to prove that the defendant is guilty of 2 counts of negligent homicide while under the influence for the untimely deaths of Tim Parker and 3-year-old Pippa Parker. So, my point in all this is that if you looked at the first version, you would have had no idea that as a result of this incident, a 3-year-old child died. You would have had no idea that the death of that child was preceded by some pretty awful injuries. You would have had no idea that as to the amount of drugs that were done, what time it happened, the fact that it happened overnight, the fact that this 3-year-old was drug along with these folks to go party all night. One of the details that I didn't put in there, but it's in our fact pattern, is that when the vehicle crashed, the 3-year-old was not put into a car seat either. So again, it goes to the negligent aspect of this case. So you have to understand too that the manner of death is not something that may be in dispute in a case. Some of the details about the age of the defendant, while really not really germane to maybe the elements that the state has to prove, if you have a jury that's a little bit older, they might look at her and think that she's a little more reckless, that she's more prone to do these kind of things. So some of these details are just examples of things you can put into your openings, to your closings, and to get out through your witnesses, because really, storytelling does not just end at doing an opening. or arguing a motion or doing a closing. The storytelling has to go throughout the entirety of your trial. And all these details are things that have to come out, or you're going to want to come out, to really truly advocate for your client, and to really pull at the heartstrings of the jury and to really paint the picture for the jury. Some of the best openings that I've seen in my career have dealt with just facts that just really had nothing to do with the case. The fact that it was raining and there was glass on the window pane, which really had nothing to do with the case, but hey, I can see that. So I guess my overall point to you is that as you go from students into practice, don't forget the details and the crucial details and the details that paint a picture whenever you tell your stories, either in your motions, your openings, your closings, or in any way you're called to advocate for any of your clients. With that, again, I just want to thank all of the panelists. It's been a pleasure to be with you and hear you tell your stories as well. And thank you again to the Board of Advocates and the Law Forum as well.
Thank you so much, Ben. That was very insightful. The first story, we had vague details. We didn't have the defendant's name. The second story, I felt like I was even watching a Lifetime trailer where I get, I know everyone's nodding their head. Yeah, they're like, oh, wow. And she did that with Pippa, and it's a 3-year-old. So you're absolutely correct. When you're storytelling, we want to know those details. The jury needs to know those details to get to the heart of it. We appreciate you, Ben. We appreciate you, Professor Anderson, and also Chad. And now we're going to move on to the second portion, which is the Q&A. I'm going to hand it over to the president of the Board of Advocates, Kevin.
Thank you, Ben, Chad, and Professor Anderson for everything that you said. I'm going to ask you a few questions, and due to time constraints, if we could please keep the answers to 1 to 2 minutes, that'd be greatly appreciated. So I'll start off with the first question. So when all of the facts are against your client on either side, how are you able to tell a good story? So I guess we'll start off with Chad.
Well, that's the lawyer's job, is to identify that. I mean, it's to identify, you're going to get cases that the facts, it's a varying degree of strength or weakness. And when you have cases when the facts are against you, your job is to find a way. What's your defense? What can you make of those facts? What is it about that case that you want to present to that jury? Or if it's a motion that you can convey, how does that tie in? If you have to rely on, if the facts aren't with you and you have to rely on a legal argument, how do those work together? And how do you figure out a way to use what facts you have to enhance your argument? Because sometimes you may be in a jury trial and your audience may not be. You still have the jury, but you may really be fighting for, this is I'm only going to win this on a legal argument. And that's the lawyer's job. There's always something. Look, if you have no facts and you have no law, then you got to resolve the darn thing. But sometimes that's not an option. So there's always something. And so it's finding that strength and building it. And I don't mean to make it sound so simple, but that's what we do.
We definitely don't think it's simple, but thank you. All right, Professor Anderson, when all the facts are against your client on either side, how are you able to tell a good story?
Well, Chad really gave a really very good answer to it, a very solid lawyerly answer. I'll add one thing to it, which I think was implicit in everything he said. It's the lawyer's job to navigate how we're going to do it. But I have learned that sometimes when you have the inconsolable client or the case that won't go away or won't settle, sometimes I just resort to, first principles. Don't go to the complicated if you haven't done the simple. Ask your client, what do you want me to do? We've got some bad news here on the facts. We're going to go in front of these strangers and ask them to do something that I think it's going to be difficult to ask them to do, but it's your case. What would you like them to hear before maybe they give you good news, probably bad news? To let them have an opportunity, to be involved in the litigation process is sometimes empowering for clients, but you can't make your client do stuff all the time. The title is attorney and counselor at law, but I got to tell you, I know that Chad and Ben have had more than their share of clients who don't listen to us. We hang all that stuff on the wall. At the end of the day, that's the part you have to navigate. And sometimes you are left in a position that you got to fight the case that might seem not unwinnable. But I think Chad is right. There's always something that can be done. And you need to be prepared to do your job. But I just sometimes ask the client after I've given them the difficult part about what's wrong and says, well, what would you like me to do? And then we'll talk about that, and maybe that'll help me develop my plan.
And then again, when all of the facts are against your client on either side, how are you able to tell a good story?
Yeah, what Chad and Professor Anderson said, you know, there's not a lot I can add to it. One thing I would the way I'd kind of twist the question is kind of to pick up on something that Professor Anderson just said. When your client doesn't do kind of what you expect them to, you will inevitably in a deposition or a trial have your client on the stand, and they will just say something completely off the wall, or say something that completely contradicts what they've said. I've been in that situation, and there's just, you know, many a times in deposition, trial, whatever, and there's not much you can do about it. Some of the best trial attorneys that I've seen, and I try to do this myself, is when that happens is just to keep that poker face. Don't let it affect you, because if you become deflated, roll your eyes, or, you know, something, you're going to draw attention to it. So in that instance, it's, you know, the best you can do is really just to kind of roll with the punches, so to speak. Move on quickly to the next question. Hopefully there is a next question to go to, and hope the jury didn't pick up on that, and maybe importantly your opposing counsel didn't pick up on that either.
Perfect. And just so Chad doesn't get the first word on every question, we'll start off with you, Ben. Can you tell us an example of when storytelling did not work out for you? Alternatively, can you tell us about when storytelling did really benefit you?
Sure. So two concrete examples come to mind, and we'll get the bad stuff out first. So when it didn't work out for me, there was a case that I tried that I was pretty confident I was going to win a couple of years ago. It was a jury trial, and basically the other two parties were kind of pointing the finger at my client, but their versions and how the incident happened were completely different. And so my closing, you know, rather than telling my client's story about what she said happened and seemed perfectly logical to me, all I did was focus on the other side and say, well, he said this and he said that, so their stories don't match. And I spent the entire time just talking about, you know, the problems in their story, but I didn't focus on my client's story, her version of events and what happened. And the jury found against me, and I was shocked. But really going back and thinking about it, I mean, there were some other factors, of course, too. But I really think if you really don't focus on your client's story, your theme, your theory of the events, and argue that in your closing, or really bring that out, it's it may send a message to the jury that you don't really believe your client. So always focus on their version of events. One time when it did really work out for me, I had a case where it was a motor tort. My client had two kids, driving them to school, happened to slide on some water, slid into another vehicle. Person claimed injuries. It wasn't that bad of an accident, but in any event, when we picked the jury, I noticed that there were a lot of, it just happened this way. There were a lot of females on the jury who were, you know, in their mid to late 30s to early 60s, I want to say. And I wouldn't know, I mean, they were all married too. And I wouldn't know if they had children based on the information that was given to me, but, you know, presumably they did, or they were aunts to their brothers and sisters' children, so they knew what that was like. So one of the things I added to my story in opening was the fact that, and this is true, that my client's husband was out of town that day. So she was tasked with getting both kids up, both kids dressed, fed, out the door, all that stuff. And you know, I really didn't think much of it, but, you know, I got a lot of head nods from the jury as I'm telling the story, So I really think if you know your audience and know who you're talking to and can tell a story that maybe they identify with or that they've experienced themselves, it can help. And I won that case, or I definitely got a great outcome out of that case. And I don't know if it was because of that, but I certainly had the jury's attention at the outset of the case. So that's my example of a good storytelling, I guess.
It certainly didn't hurt. So Professor Anderson, again, can you tell us an example of when storytelling did not work out for you? Alternatively, can you tell us about when storytelling really benefited you?
Wow, I hate this question. It's a great question. Whoever came up with a great question. Okay, when it didn't work out. Okay, so when you're putting a story together for a trial, usually you need the pieces to put the story together. So it involves witnesses, fact witnesses, experts, exhibits. I had an expert in a case. He was like a renowned guy in the world. We drove down to where he was, the Virginia College of Medicine, and we prepped him. He was so good in practice. He was so good in practice. So I'm like, oh, here's the path to victory. That gentleman got on the stand, and I was thinking, like, well, because this is Halloween, right? Sci-fi, right? Body snatch. Where did my guy go? Someone took over his body and left me this guy, and my case is slipping away before my eyes. And wow, what a day that was. I mean, it's like a nightmare. No way to know that was gonna happen. So that one was easy. The worst, when storytelling didn't work, because now the middle of my story's gone. So it was best. I had to think about this one. I was involved in defending a case, civil case, where a neighbor beat up a neighbor, a dispute in a neighborhood over something. The guy had a big potato chip truck and he parked it and blocked all the parking. This is Baltimore. You all will relate to when parking sucks or is rude, right? It's like a nightmare, right? So this whole case turned on our client that we were defending in the civil case. He beat the guy up. He was convicted of beating the guy up. It's like, is this just going to be like a long civil liability plaintiff's verdict? What else do you talk about in the case? Well, we had a witness that was the oldest person who lived in the neighborhood. Older lady who had been in the neighborhood, took the witness stand with a cane, sat down, and she told the story of how the neighborhood used to be a nice place till the guy who got beat up moved in there. She just laid out, his problems as a neighbor, how troubling he had been, how he parked that potato chip truck, how everybody thought he was a nightmare. And the jury came back finding my client guilty of battery, but giving 0 damages, which means that you got the defendant's verdict. You didn't make out one of the elements. They were like, even though you got beat up, we're not giving you a nickel for it because you're such a horrible person. I got to say, that was a great moment as a lawyer to say, how are you going to get around this real bad problem? But the story was told through this witness who overperformed. I mean, I didn't know if she was going to be able to get to the witness stand, but when she got up there, it's like she wanted to throw all the burdens of the neighborhood on that jury to say, if we could just get this guy out of there, it would be a nice place to live again. And she overperformed. So underperforming witnesses, overperforming witnesses. I just throw that out because it's just so memorable. It's like it was yesterday. I feel both of those moments.
That's a great stark contrast. Oh my goodness. So Chad, same question. Can you tell us an example of when storytelling did not work out for you, or alternatively, when storytelling really benefited you?
It didn't work out for me in a case where there were multiple defendants and they all started pointing the finger at each other, which is unfortunately a contagion within the defense world where they point fingers at each other. And the lesson is don't do it. As Benjamin will attest, don't do it. Stick with your story. Let the other people fight. But it was a situation where, because there was so much of it, it actually drowned out the story that I had developed for the physician, which was a tough case, and I had come into it late to help out a partner of mine. And in hindsight, I needed to adjust. I picked the wrong central theme, and I didn't anticipate how it would have played out at trial. And I could have even made the adjustment probably in closing and didn't. And it's a lesson that it's not just the matter of a story. You have to have the right themes. You have to have the right elements. You need to connect with the jury, that jury issue. What is that theme? What is that issue that's going to connect? And I chose the wrong one. So the story, and therefore the story was flawed. When does storytelling work for me? Storytelling has worked for me just in every other trial I've tried in the past 12 years. It just has. It's allowed me, but I give you an example of, not in a trial, but in a motion. Was it represented a physician in an awful bus accident case that in Catonsville, there were a MTA bus plowed into another bus. There were 6 people who died and 20 people were injured. There were all sorts of people, all sorts of entities sued. The prime target was the company that was supposed to screen the bus driver and didn't do their job. Their defense was to blame my doctor. And I wrote a 30-page motion for summary judgment. 26 and a half of it were facts. It was simply the story. Now, embedded in those facts were the legal background that the judge would need, and it was everything, and the argument, but it was a story. And then I just cited the law and cited everything, and we won. We got a motion for summary judgment, which is not the easiest thing in the world to do these days at circuit court. And we did that. We had good testimony, but we were able to organize it in a way that made sense for the judge. And that's, for me, one of the prouder moments of using the same storytelling techniques. I had worked up the case for storytelling. We had everything in place, but to apply that in a motion for summary judgment was something I'm very proud of.
Well, that's a perfect segue into our next question for Professor Anderson. So while there is plenty of storytelling in the actual courtroom, is there any storytelling before the trial begins, such as with motions or complaints?
Yes. The first thing I want to say is this. Your written documents gain the confidence of your judges. Make the judge happy by making sure your documents are clean, proofread. It's, the basics of communication. Okay. So, all the people that are, on journals and, working on other things, and you're doing your writing, please understand that your professional reputation is in your written product. You are not going to snatch victory from the jaws of defeat if you've got sloppy documents. It's not going to happen. And then you're going to create problems for yourself with credibility when the higher stakes stuff happens down the line. So just keep it ever in front of you that you want your stuff perfect that you file. And I would say also, again, opportunity for telling the story well comes every time you get a chance to tell it at some stage of the case where you're arguing a motion, where you're discussing which issues are going to be dropped, summary judgment motions, any kind of, every time we try to write the story, we try to tell the story, but I think most lawyers would be honest to say, they're often surprised at what fact or what point of law actually breaks a case. I mean, we've got an idea and a framework for what's going to do it, but we always have to be vigilant to say every time we talk in a paper or in a conference or even in a phone call, what's going to really break a case as part of the story, of the piece of the story that you're trying to tell. So that would be my response.
Perfect. And so Chad, again, while there's plenty of storytelling in the actual courtroom, is there any storytelling before the trial begins? And I know you already said the motion, maybe a complaint?
Storytelling starts the moment you get the case. You're starting to write your story at that point. Every witness in the case is essentially as part of the cast for the story. So every witness serves a role and supplies a piece of information or two for the story. So you are building you get the case and you're thinking, what are my themes? What am I building here? And, for example, when you get a medical malpractice case, one of the first things I look at, and most of the time, is, okay, what did my physician do to help this patient? That's my theme. That's not what the standard is for that, the question that goes to the jury, but that's really what matters. So I'm building, that's my theme, and I'm going there and using the medical records and the witnesses and building. And there'll be other pieces of information, medical records, scientific stuff. It all plugs into that. So your story starts right away. When you're writing a motion, it's, you want to make sure that judge understands the facts in the story. It influences the decision-making. It's critical. No one makes a decision in a vacuum. So, and I could have an entire lecture. I could probably teach an entire class on just the start, what you do. But that's where that's where it begins. So it's everything.
And I'm sure that'd be a great class. And so Ben, same question. While there's plenty of storytelling in the actual courtroom, is there any storytelling that actually happens before the trial begins?
So Chad probably much more eloquently took exactly what I was going to say, which he's absolutely right. I mean, you get a case in, you got to look at it. What I would just add to that, and understand, in the civil context, discovery is so open. There's a lot of things that are disclosed, but there's still some element of surprise in some cases. I handled a matter one time where the very outset of the case, it was basically an insurance company coming after my guy for an accident they said he caused. But the only person who actually testified to what actually happened, the other driver, after I did some initial research, come to find out he's sitting in jail in North Carolina on his third child pornography charge, which was surprising to me. But I kind of sat on that fact for a little while. It's not something I came out at the outset and told the opposing counsel. I waited on it. Discovery, we answer interrogatories. There's no request for anything specific like that. So that didn't come out. Then, the deadlines come and go. My client hasn't been deposed. I'm like, okay, well, whatever. Not that he would know that fact. The night before and consistently, my adjuster wanted me to make an offer of $1,000. Just keep it at $1,000. Let's see if we can get it there. I'm like, okay. So I keep getting settlement demands, and finally, when I'm down pretty low, the other attorney calls me in exasperation, said, "Why aren't you putting more money on this case? Why aren't you settling this case?" I'm like, "Well, do you know where your client is?" They're like, "Yeah." And well, are you sure? Are they going to be able to come to testify? And just left it at that. And I got a call probably the next day saying, "Yeah, we'll take your offer." So it's kind of when I guess to add to that, it's when you decide to drop certain information that you're kind of holding on to tell your story, to kind of give a surprise, so to speak. That also kind of comes to to kind of add on to what Chad said about the story begins when you first get the case.
Perfect. And so there is a question from the chat, and I'll give Chad the first word. So what are some storytelling techniques to prepare the jury for negative information that may come out about your client?
And that's not necessarily a storytelling technique at first. It's if you have that negative information, there's a decision about whether you disclose it, knowing that the other side is probably chomping at the bit. So if there is something negative about your client, you probably stand up an opening statement and talk about it. It's a tactical decision in terms of using storytelling with regard to that negative information, whether it be maybe some sort of disciplinary action, maybe some sort of a prior accident that the judge allowed in under rule. It just becomes part of the beauty of storytelling is that you can use that negative element, that event, to actually as a setback for your client. If they made a mistake. So essentially, if you can get it so your client owns the mistake, yes, I made a mistake. I made this mistake, but I have moved forward, actually is a way of actually enhancing the story. Because again, it's huge. Now, again, it depends on what the negative is. There's negative and then there's really negative, a spectrum. But it isn't, you can incorporate that within the story. And one of the elements of the journey of the hero and applying it in for a trial lawyer is your client must own everything they do, every positive and every negative. No excuses. People hate excuses. If they own it, if they stand up and yes, I did it and my fault. I screwed up, but A, B, C, D. You know what? Jury will forgive them if they own it. So that's how it just becomes part of the overall story, and the phrase is owning everything the hero does. That's in the context of a story.
Accountability is very important.
Absolutely.
So Professor Anderson, same question. What are some storytelling techniques to prepare the jury for negative information that may come out from your client or about your client?
Yeah, this is always a tough one, because you usually never, it's great if you can anticipate it and build it into the storytelling, but just let me give you a couple of facts and a couple of approaches. And I haven't asked anybody to write anything down tonight, but there are two things, if I'm going to say, that you're going to write down tonight. Here are two of them. And you can attribute them to me, you can take them as your own, no problem, or issues with plagiarism or anything. Okay. First thing, learn to ask your client, particularly if the client is the one that could have some, is the main story you're telling. Sir, ma'am, please do me a favor. Whatever you do, don't make me the dumbest person in the room. If you make me the dumbest person in the room, the only thing that's going to happen is you're going to get hurt, and I'm going to be the object of your hurt. I'm going to be the one who's going to hurt you, because I will be underprepared, and then we're not going to have success in a terrible way. So don't make me the dumbest person in the room. You're free to use that as an intro to dealing with negative information. The other one is this. I've done a lot of research on juries. We all think we know something about juries, but the truth is they're a great mystery. But I will give you one thing about a jury that's not a mystery. You can write this down. I don't care who they are, where they are, what they're deciding. They hate to be lied to. And if you lie to them once, you're never going to get them back. And so make sure they never perceive that you've done it. That's why what Chad said was so important about owning it, because sometimes the lawyer is going to have to take one for the team. The lawyer is going to have to somehow make it so he's owning it and absorb it, right, as part of, the advocacy piece of telling the story. We brought that information to you. We tried to make sure you knew what was going on, but that has nothing to do with the primary issue, with whether or not there was negligence or whether or not there was responsibility. So those are the two takeaway lessons tonight from my perspective, because those you can count on will give you really, you can't put enough antacid on your nightstand to deal with those two things if they happen in the midst of your trial. So try to avoid and reduce the possibility that it comes up too much.
Exactly. No one likes to be the dumbest person in the room. So Ben, you get the final word. What are some storytelling techniques to prepare the jury for negative information that may come out about your client?
Well, in terms of prepping the jury, I would say, you got to make sure your client's prepared to do what our panels have already discussed, which is to own up those faults or prior incidents that are going to come up in trial. If you do criminal defense work, you're not going to, very rarely, I think, but a lot of times you're going to find yourself in trial representing people who have some checkered past. But doesn't make them bad people, and quite frankly, they could have been been caught up in a situation where they had nothing to do with anything going on, and they're just caught up by the circumstances. But if you have an individual who's pretty far removed from some incidents or bad acts or prior crimes or issues that may come up, prepping them to explain to the jury what was involved, what was going on. Even in the civil context, I've represented numerous clients who have been arrested. I represent a lot of truck drivers who have in the past had a lot of, drug issues in the past. You see a lot of, thefts, theft convictions when they're, their younger years, they've got a problem and they're trying to overcome it. And then years later, they're in trial in a civil matter, and all of a sudden I have to say, hey, by the way, this prior crime, from 7, 8, 9, 10 years ago might come up in this case. So really it's prepping your client on to explain to the judge or the jury what that was, what it was all about, how he or she has overcome that problem, the steps they've taken to battle the drug addiction or the crowd they were with, or get out of the situation. And to kind of, touch upon what Chad said earlier, we all love a hero, but I mean, even the classical hero has their own flaws. So I think to highlight that, but also to use that to humanize them, to show the issues they've overcome in their past, can sometimes work in your favor and really have a jury who might have their own, skeletons in their closet, or family members or friends who've had those issues, to say, yeah, that's just like, my brother, or that's just like, my friend who had that problem, long time ago. I can really, in that context, prepping the jury for those issues is really prepping your client to allow the jury to then connect with your client to say, yeah, they may have had some problems in their past, but they've done a lot of good work to overcome them. So it makes your client more credible at the end of the day, or it can.
Perfect. Thank you so much. And before I hand it off to Amani Payne for some closing remarks, I'd like to say thank you to our panelists. Thank you to Issa. Thank you to Amani for everything that you've done. We really appreciate it. And again, just a quick plug for the Board of Advocates. I'm on trial team now, and Ben has done a wonderful job. All the things that he said, I've heard it already once before. He's done a great job. But again, thank you all so much for attending. And Amani.
Thank you so much, Kevin. And now I'm actually going to hand it over to Issa, and she's going to give some closing remarks as well.
I'm just going to go ahead and add on to everything everyone has said. Again, thank you everyone for coming. Thank you to all our speakers, to the Board of Advocates, and of course to Amani for putting this event together. And also a special shout out to our advisors, Professor Valerio and Dean Diamond. Thank you for all your help in this process. I hope that everyone enjoyed tonight's event. I know that I learned a lot. And as I mentioned earlier, please feel free to email me if you would like to subscribe to our journal. My email is in the chat if you have any questions. Amani, you can take it from here.
Thank you, everyone. Thank you, Issa. Thank you, Kevin. Thank you to our panelists who were absolutely amazing. And what I want to point out is that each one of our panelists were very different and very unique. They're very seasoned, they're very effective, and they all have a different style. But the common theme was you have to find your style, you have to tell the story, and you also have to be transparent with sticking to the facts so you can advocate for your client. With that being said, closing remarks. Thank you so much for coming, participating. I know I learned a lot. I know you guys learned a lot. So you guys enjoy your weekend. Thank you.